Will your injury case end up in court? Many assume every lawsuit means a trial, but the truth is, it's the opposite. In this video, I'll show you what actually determines whether your case goes to trial, why most personal injury claims settle before ever reaching a courtroom, and what to expect if yours is one of the rare cases that does go before a judge or jury. Hey, I'm attorney Louis Bourgeois, your Louisiana injury attorney. I spend years helping injured folks just like you fight back when insurance companies try to take advantage of them. If you've been injured in a crash and need someone in your corner, give me and my team a call today at 504-882-9867 for your free consultation. Remember, when you want to win, you gotta give them the L. Let me ease your mind right away. The vast majority of personal injury cases in Louisiana never see the inside of a courtroom. Most settle through negotiations long before a trial date is ever set. But that doesn't mean the threat of trial isn't important. In fact, being prepared to go to trial is often exactly what pushes insurance companies to offer fair compensation. So what decides whether your case settles or goes before a judge or jury? Let's break it down. Several factors influence whether a case settles or proceeds to trial, and understanding them helps you know what to expect. First, liability and fault. If the evidence clearly shows the other driver caused the crash, insurance company knows they'll lose in court. That pressure often leads to a reasonable settlement offer. But if fault is disputed, if both sides have different stories and weak evidence, the insurance company may refuse to settle, forcing the case to trial where a jury or a judge will decide who's telling the truth. Second, the value of your damages. When your damages are severe and your medical bills, lost wages, and pain and suffering add up to a substantial amount, the stakes are much higher. The insurance company may settle to avoid the risk of a jury awarding even more. But if they think they can get away with paying less, or if they believe your damages are exaggerated, they may dig in and force you to prove your case in court, thinking, what do we have to lose? Third, insurance coverage limits. If the at-fault driver has strong coverage, the insurer may be more willing to settle within those limits to avoid the cost and avoid the uncertainty of trial. But if the defendant is uninsured or underinsured, or if the policy limits are too low to cover your damages, settlement becomes harder. In those cases, trial may be the only way to pursue full compensation. Fourth, the willingness to negotiate. If both sides are acting in good faith, willing to compromise and meet somewhere in the middle, settlement's likely. But if the insurance company makes lowball offers or refuses to budge, or if they're playing games to delay and frustrate you, trial becomes the only option to force a fair outcome. Fifth, legal representation. Having an experienced attorney makes a huge difference. We know how to build strong cases, negotiate effectively, and make it clear we're ready to go to trial if necessary. Insurance companies respect that. They'd rather settle with a lawyer who's preparing to fight than risk losing big in front of a jury. Finally, the party's tolerance for risk. Trials are unpredictable. Neither side can guarantee the outcome. That uncertainty often motivates settlement because both sides want to avoid gambling. But if one party feels confident in their position, or if they have a strategic reason to go to trial, they may refuse to settle. All of these factors work together. A case with clear liability, serious injuries, strong evidence, and good legal representation is far more likely to settle on favorable terms. But when any of those pieces are missing, trial becomes a real possibility. Even though most cases settle, some do go to trial. Here's why that happens. Sometimes the parties simply can't agree. They're too far apart on who's at fault or what the case is worth. When negotiations break down and neither side will budge, the only way to resolve the dispute is to let a judge or jury decide. Other times, the insurance company makes an offer that's insultingly low. Maybe they're offering $10,000 for a case that's clearly worth hundreds of thousands. At that point, you're better off rolling the dice in court than accepting a settlement that doesn't even cover your medical bills. Occasionally, a case goes to trial because one party wants to set a legal precedent or make a public statement. This is rare, but it does happen. Someone may feel strongly that their case will establish an important principle, and they're willing to take a risk to make that happen. Legal strategy also plays a role. Sometimes your attorney will advise you that trial is the better option because the evidence is so strong, the jury is likely to award more than the insurance company is offering. In those cases, filing a suit and preparing for trial is part of the plan from the start. For some folks, it's all about the principle. It's not about looking for money. They just want their day in court. They want a judge or jury to hear what happened and hold the responsible party accountable. When that's the driving force, settlement may not feel like justice. And finally, if the defendant is uninsured or underinsured, there may be no meaningful settlement offer to accept. If they don't have the money or courage to pay, trial may be the only path to any compensation at all, even if it means pursuing a judgment that's hard to collect. If settlement fails and your case proceeds to trial, here's what the process looks like. First, your attorney's going to file a formal lawsuit, a petition for damages. This is the legal complaint that officially starts the court process. It lays out the facts of your case, who we believe is responsible, and what damages you're seeking. Once the lawsuit is filed, the defendant or the responsible party has a set time to respond. Once they respond, the next phase will be discovery. This is the phase where both sides are going to exchange evidence, take depositions, interview witnesses. Your attorney's going to be gathering medical records, asking for documents from the other side, obtaining expert opinions, and obtaining anything else that is needed to prove your case. The defense is going to do the same, looking for any weaknesses in your case they can exploit. Before trial, there's going to be some pretrial motions. These are legal arguments that are filed by both sides to resolve certain issues or narrow the scope of the trial. For example, the defense might try to exclude certain evidence, or your attorney might file a motion to clarify the legal standards the jury will apply. Then comes the trial itself. Both sides present their evidence, call witnesses, and make arguments. Your attorney will explain what happened, show the jury your medical bills and records, and demonstrate how the crash has affected your life. The defense is going to try to poke holes in your story and your credibility and minimize your damages. At the end, the judge or jury is going to deliberate and issue a verdict. If you win, the court issues a judgment in your favor and awards damages. If the defense wins, you receive nothing, though in many cases your attorney can explore options for appeal. Trials can be lengthy and stressful and cost a lot of money. They require preparation, patience, and the willingness to let strangers decide your fate. They may also be the only way to secure the compensation you truly deserve, especially in cases involving serious injury, permanent disability, or the insurance company refuses to act in good faith. Whether your case goes to trial or settles, having a strong legal team is critical. An experienced personal injury attorney can gather the evidence, negotiate aggressively, and prepare your case for trial. Also, make sure you meet Louisiana statute of limitations or prescription, which give you just 2 years from the date of the injury to file your lawsuit. Miss that deadline, and you can lose your right to compensation altogether. If you're wondering whether your case is significant enough to go to trial, or just wondering about the process at all after your injury, I'm Lloyd Bourgeois. Call me and my team today at 504-882-9867 for your free case review. We'll review your case facts, explain your options, and if necessary, fight to get you the compensation you deserve, whether that's through negotiation or at trial. Remember, when you want to win, you gotta give them the L. And if you found this video helpful, hit that subscribe button right there and check out this next video.